We'll wait till people join real quick. Peace. Peace. So I'm gonna be going over this letter right here. This is from the Rhode Island Attorney General's office. This is what they sent. They sent a quote-unquote response to my writ of discovery. What they sent was this packet right here, which is what I already have from the appearance that I made to the 6th District Court when I got Gabrielle Perlmutter's name. It's like the 11-minute video that I recorded when you heard her say, for the record, she's handed me discovery, which was what they had at the time. But since then, I had written my own discovery requesting specific information. So I'm not going to read my first affidavit because I already read that. I'm going to read, what is this one? Oh, this one's I'm going to read the conditional writ of discovery. So this is what I sent to them. Right? I'm not gonna read this because I already read it before. It's a conditional writ of discovery under the conditions that they don't honor my other documents, which they haven't. Which I'll probably go over that too in this video. But here's the facts. Right, this instrument is titled Conditional Writ of Discovery to compel the opposing side to offer any and all information regarding this issue and specific information regarding this issue in the event that the court, via the unconstitutional decision of the biased justices or magistrates, to continue with the case in violation of Article 3 and 6 of the Constitution, as well as 28 U.S.C. 1331 and 28 U.S.C. 1332, as well as any and all other issues brought up by Jamal Tlaib Abdullah Bey that cannot be disputed without warring against the American people. And here's my discovery. Pursuant to the law of both federal, civil, and criminal procedure, the Constitution, state laws, and statutes, I hereby demand that the prosecutor release any and all information specifically highlighted pertaining to this case as per individual request, to include but not limited to a video footage of the Rhode Island State House whereby Julissa Amora Adonai El allegedly assaulted several state troopers in the State House, was able to leave, then enter through security again without being arrested, while there were approximately 5 state troopers in uniform with several civilians recording. B, the original or certified original copy of the warrant signed by a judge that was allegedly presented by the police, which already based on this document that they sent from the Attorney General's office, A and B have not been satisfied so far. And of course, C, writing in the warrant that states the police can enter the home or property listed in the warrant and tamper with recording systems installed into and on the home, which that also wasn't answered in their response to this writ. D, writing in the warrant or any laws that states the police can delete recorded footage of them breaking down the door to a home after they unlawfully arrest the persons recording them, which they haven't produced any of that in the discovery. E, specify in writing what anti-police rhetoric is, as written in the police reports or narrative of the several alleged policemen, which that was never given. F, provide video, audio, script, writings, logograph, or other visual or phonographic evidence of Jamal Tlaib Abdullah Bey expressing in full context his alleged anti-police rhetoric, as written in the police reports or narrative of the several alleged policemen, which they haven't produced. Note, it is stated in the narratives provided by the prosecutor that the police have viewed Jamal Tlaib Abdullah Bey's YouTube channel, and they are therefore able to provide the requested video, audio, or other media forms of Abdullah Bey expressing what they call anti-police rhetoric, which they haven't given me. Which, again, this right here, this is their their response to my discovery, which they didn't even answer. So I'm gonna show you my response to their failed attempt to answer to my discovery. So none of these were answered so far, all the way up to F. G. Provide any and all information that has been briefed to the state police from the agency itself or any other agency to include but not limited to the FBI regarding the Rise of the Moors organization. As stated in the police narratives, information was relayed to members of the VFTF, which is the Violent Fugitive Task Force, regarding aligned members of a sovereign movement called Rise of the Moors. Informational briefs regarding the Rise of the Moors movement. So that's what they stated in their police report. So I want to see what this brief entails. Also, specify which agent and which agency provided said information, and specify if the Rise of the Moors and its members are listed on the FBI's Black Identity Extremist list. Also, as well as proof that any officials of the Rise of the Moors has referred to themselves as a sovereign movement or expressed that they think that the federal laws of the United States does not apply to them, despite the members going to federal court to file claims, with various newspapers proving that they go to federal court and abide by federal laws, as well as cases with dockets in the federal court of Rhode Island and federal courts of appeals. H. Provide medical records and or images of any bruises sustained from the alleged push or other assault on any state troopers as claimed in the police narratives, proving that there is an injured party and statement of claim upon which relief may be granted, which they have not produced. Provide information in regards to whether or not the police know what a bait and switch is, and specify if using that tactic falls within the scope of police conduct, which they have not produced. J. Provide information regarding police conduct in regards to them showing up to a dwelling, home, property, domicile, or residence in civilian clothing, being sufficient enough to clearly identify a police officer. Also provide information that clearly shows that it would be impossible for a criminal to acquire a badge, dress in civilian clothes, and knock on a person's door claiming to be police without a warrant in their hands while claiming to have a warrant. Also provide proof or evidence that it would also be impossible for a criminal to obtain a warrant to clearly identify violation. M. Provide a list of names and addresses of any and all or injured parties as a result of the issuance of, and the same information for alleged assault that allegedly sustained injuries in the Rhode Island State House, as well as images or medical records of said injuries and the police reports filed by the alleged injured party, along with the default summons issued to the assailant to have a hearing regarding said alleged assault with proof of service. This is needed to determine the validity of said warrant, which resulted in the police causing $6,000 worth of damage to the listed defendant's property. N. Provide any and all video or audio recordings of all parties listed in the police narratives in police custody, and video and audio recordings and documents of the same listed parties when they were taken to prison, given inmate ID numbers, forced into a machine that provides warning that it causes radiation, and all video and recordings of all other personnel and listed parties in the police barracks, to include all retina scans, fingerprints, and handprints, DNA samples, photographs, reports, and the like of the listed parties in the police narratives, including but not limited to any and all legal and illegal surveillance, wiretaps, bugs, or the like, under penalty of perjury and prosecution from the Moorish nation. I do declare and state for the record, to the best of my ability, with a sound mind and conscious mind and heart, without malice intent, that all claims and statements made in this instrument are true, factually and lawfully based, and not made for nor intended to be used for fraud, misrepresentation, mispersion, nor usurpation. It is furthermore stated and affirmed that all statements made are made in pursuant to and respect for the federal constitutional and treaty laws, of the United States, and the natural, ecclesiastical, civic, theocratic, and national laws of the state of Morocco, a free Moorish American national and citizen of the Free National Government of Morocco. I am Jamal Talib Abdullah Bey, all rights reserved in honor of my Moabite ancestors to time immemorial, exercising the divine and common law right to just post-limity, in accordance with the high principles of love, truth, peace, freedom, and justice, as commanded by my holy prophet and guide, El-Hajj Sharif Abdul Ali, Noble Drew Ali. I affix my autograph / signature here too. So that was my discovery that I sent to them. This was their response. with the same packet of information that was already handed to me by Gabrielle Perlmutter that did not answer any of the questions that I asked in my discovery, which in the video that I recorded in the court, you'll see where Joseph Terrence Houlihan Jr. stated that both parties have to reciprocate discovery, and that if it's not reciprocated, then there has to be a discovery hearing. So that's what came out of that so-called judge's mouth. So since they didn't answer anything that I asked or provide anything that I asked for, this is what I responded with. This was the 6th day of June, 2020. I'm going to read the disclosure statement on this one because it's shorter. This affidavit of fact is not to be mistaken as a submission to jurisdiction, nor is it proof or evidence of the recognition to the validity of any alleged claims or complaints made by the plaintiff. This is solely, strictly, and only for the purpose of Jamal Tlaib Abdullah Bey to remain in honor and maintain his innocence. This affidavit of fact and writ of dismissal is being filed with the court in response to a letter received from Megan E. McDonald, dated June 15, 2020, and being sent to Megan E. McDonald, Assistant Attorney General, Unit Chief, Assistant Attorney General, Unit Chief, District Court, and Family Court Unit, and Gabrielle Perlmutter for the following. 1. The prosecution is in contempt of court for evading and failing to completely answer all of the questions in the conditional writ of discovery filed with this court and sent to the prosecutor. See Rhode Island General Laws 12-17-16, Defendant's Right of Discovery, and Rhode Island District Court Criminal Procedure 16G, Continuing Duty to Disclose, Failure to Comply. Number 2, this issue must be dismissed for lack of prosecution. The prosecution, justice, magistrate, judge, or any other officer of the court or of the state is barred from claiming that due to COVID-19, the courts were closed and there could be no prosecution, or the courts were closed for any other arguments. See Rhode Island General Laws 12-10-1, Courts Open at All Times, and Rhode Island District Rules, Criminal Procedure, Rule 48, Dismissal, B, by court, if there is unnecessary delay in bringing a defendant to trial, the court may dismiss the complaint, and Rhode Island District Criminal Prosecution, Rule 2, Purpose and Construction. These rules are intended to provide for the just determination of every criminal proceeding to which they apply. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of unjustifiable expense and delay. Number 3, all affidavits and writs filed on my behalf have not been rebutted word for word and therefore stand as evidence. Additionally, the courts have failed to prove jurisdiction on the record to hear cases in which the federal question is raised and where there is an issue of diversity of citizenship and nationality. Only federal district courts have the jurisdiction over both federal question and issue of diversity to include treaty issues or issues upon which a treaty can or has been enforced. In general, a judgment is res judicata, not only as to all matters litigated and decided by it, but also to all relevant issues which could have been, but were not, raised and litigated in the suit. And then some more res judicata that I'm not going to read. And then some more res judicata as an example. Allegations and affidavits must be considered as true in the absence of counter affidavit. All right, I'm not going to read all this res judicata. If you want this res judicata, go to riseandmores.org, click on products, go to writs, or go to books and click on res judicata. You can get all this stuff. Number 4, this issue must be dismissed for violation of both the federal and state constitutions. See Rhode Island Constitution, Article 1, Section 10, Rights of Accused Person in Criminal Proceedings. In all criminal prosecutions, accused persons shall enjoy the right to a speedy trial by an impartial jury. Speedy and public trial by an impartial jury, and the Constitution for the United States of America, which all judges, magistrates, justices, and attorney generals take an oath to. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by a law. And H.R. 17409 of the 93rd Congress, 1973, to 1974 Speedy Trial Act, speedy trials, provided that in a case involving a defendant, the appropriate judicial officer shall, after consultation with the counsel for the defendant and the attorney for the government, set a day certain for the trial, asserts that the trial of a defendant charged with an offense shall be commenced as follows. 1. Any information or indictment shall be filed within 30 days with specified exceptions. 2. The arraignment shall be held within 10 days of the filing date with specified exceptions. And 3. Where a plea of not guilty is entered, the trial of the defendant shall commence within 60 days. 60 days from the arraignment. Now, on their paperwork, it says not guilty. That's what it says. From the Attorney General. It says not guilty. Right? Now, let me see if I can find it on their documents. On when all this stuff happened. So you can see that we are way past 60 days. So I'm going to show you their documents. I'll show you right here. That right there says 3/5/20. These are the so-called charges. Right. 3/5/20. So according to the state constitution and the federal constitution, we have the right to a speedy, public, and open trial. And the Moors that showed up the other day, you'll see where they try to restrict people from coming in, which all of you are witnesses, whereas they try to make it a private proceeding, not a public trial. You'll see that on that day, I think it marked the 114th day, which is way more than 60 days. And then, of course, they scheduled retrial for 8/6/2020, which is way past 60 days. So that's basically it. That's basically it. Any questions? Let's see. Peace. Peace. No questions. Just a bunch of peace.
Tell them to click the GoFundMe link for the Moors.
Oh yeah. Moors are trying to come out here for the other scheduled court date, August 6th, 9 a.m., 1 Dorrance Plaza, Providence, Rhode Island, 6th District Court. There's a GoFundMe out there to, not for us, it's to compensate Moors for coming out here. So donate if you can, 5 notes, 10 notes, 1 note, or $1, $10, $5, for those of you who don't know what a note is. It's going to be used for reimbursement of the Moors for traveling out here to support. Well, how's this going to get resolved? Me showing you the paperwork is how I'm trying to resolve it. They're the ones that are clearly in violation of the Constitution, both the state and federal Constitution, because I just showed you. Whereas, I'll read it again. Number 4 of my writ of dismissal in response to their alleged answering to my writ of discovery. It says this issue must be dismissed for violation of both the state and federal Constitution. See Rhode Island's Constitution, Article 1, Section 10, rights of accused persons in criminal proceedings and all criminal prosecutions. Accused persons shall enjoy the right to a speedy and public trial by an impartial jury. Now, all the Moors that showed up for court last time will tell you that the people, the guards, the armed guards said, you can't get in. So they already violated that. And also, that Friday was the 114th day. So, of course, they violated right to speedy trial. That don't sound speedy to me. That's the state constitution, right? Here's the Constitution for the United States of America. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Which is why I keep saying only federal courts have jurisdiction over this issue, because I raised the federal question and I'm not a citizen of the United States. It's already prescribed by the Constitution. It's already prescribed by law. That's why I sent a conditional writ of discovery if they agreed to violate the Constitution, which they already have. Right? Then I also show or provide judicial notice of House Resolution 17409 of the 93rd Congress from 1973 to 1974, dealing with the Speedy Trial Act, which states, provides that in a case involving a defendant, the appropriate judicial officer shall, after consultation with the counsel for the defendant and the attorney for the government, set a day certain for the trial. Asserts that the trial of a defendant charged with an offense shall be commenced as follows. 1. Any information or indictment shall be filed within 30 days with specified exceptions. Number 2. The arraignment shall be held within 10 days of the filing date with specified exceptions. And 3. Where a plea of not guilty is entered, which that's what it says in that paperwork. I never said not guilty. I said I was innocent. I never said not guilty. I never made any pleading. Check the record. I said I'm innocent. But on their paperwork, it says not guilty. So since that's what they put on their paperwork, that's what I'm holding them to, right? Where a plea of not guilty is entered, the trial of the defendant shall commence within 60 days from arraignment. https://www.congress.gov/bill/93RD, as in 93rd, dash Congress /House dash bill /17409 for your reference point. So if on their paperwork it says 3/5/2020 and they schedule trial for 8/6/2020, is or is that not past 60 days? The answer is yes. So based on the federal constitution, the state constitution, and the Congressional Speedy Trial Act, this issue is already supposed to be dismissed for lack of prosecution and violation of the Constitution, right to speedy trial, 6th Amendment, and Article 1, Section 10 of the state constitution. Should be dismissed already. And they know that. Right? So yeah, I just want to let y'all know that's what was sent. So if anyone's tracking the case, that was my response to their bullshit. Because they act like, they act like, this is why it's called color of law, because they act like they fulfilled the discovery when they didn't. I just read to you what my discovery was, and I showed you they sent me the same packet that I already got from Gabrielle Perlmutter. So what I ended up doing was I mailed this, what I just read to you, the affidavit of fact and writ of dismissal. I mailed it to the Attorney General. I mailed it to Gabrielle Perlmutter's house. I already posted her address. And I mailed it to the courts. Well, I actually mailed it to Joseph Terrence Houlihan Jr. I mailed it to him. So that's what's going on. Any questions? After the claim is filed, the accuser has 1 year to serve the defendant or the case gets dismissed for lack of prosecution. No, they don't have a year. They have 60 days upon indictment to go to trial. If it's unnecessary delays, then it must be dismissed for lack of prosecution. Yep, and you see people on the live right here telling you, yep, Morris couldn't get into the court. And they said I wasn't even on the docket, so. Can they use coronavirus delays as a reason for the case not being a speedy trial? No, I already read that to you. I'll read it again. Number 2 of my enumerated paragraph 2 of my affidavit to them. I'll read it. I'll show you. says this. This issue must be dismissed for lack of prosecution. The prosecution, justice, magistrate, judge, or any other officer of the court or of the state is barred from claiming that due to COVID-19, the courts were closed and there could be no prosecution, or the courts were closed, or any other arguments. See Rhode Island General Laws 12-10-1. Courts open at all times. At all times. That's what their laws say. Their laws say that the courts are open at all times. At all times. When did it say exceptions because of coronavirus? It doesn't. Then on video, there's video footage of people walking into the court, so you can't tell me the court was closed. Then on video, there's cops talking to us, asking us if we've been out of state, etc. Which means what? The courts are open. Any other questions? Peace, peace, peace. If you don't have any questions, I'm gonna end it. I'll be in for a little bit. If you got any questions, I'm gonna answer them. Questions. Why are they not dismissing the case? And they the law? Question mark. That's a good question. Why aren't they dismissing it? Is because they know Moors are never going to do anything. They already know Moors only send paperwork, and we only show up when it's too late, and we're not organized to prevent them from committing these acts of treason and these acts of genocide and these war crimes against us. That's why they haven't dismissed it yet. You have to stop looking at them as if they're honorable. If they were honorable, we wouldn't be in this situation. If they were honorable, no one would be oppressed right now. If they were honorable, we wouldn't be going through the shit that we're going through. There would be no so-called black and white issue. There would be no genocide against the Moors. There would be none of this. It's because these people are not honorable. They act like it on camera. They're mayors and governors and cops and military and whatever. They act like it on camera. But obviously, no honorable cop would go to your house in plain clothes without a marked car around and then claim to have a warrant. That just doesn't happen. They show up in uniform. They say, hey, here's my badge. There's my cop car right there. I got a warrant for you. And then they show you the warrant. They don't not show you the warrant. They don't show a piece of paper to a glass window for less than a minute and say, you seen it, and that's enough. These people aren't honorable. Stop thinking that they are. How much is the donation to help me with my case? I'm suing the city. Text 401-336-6799. RVBaypublications.com makes IDs. What about if I file a claim? Do I have 1 year to serve them? It depends. If you file a claim in federal court and it's accepted pro bono, then the federal courts will serve them. Exactly, still Inquisition. Then they are stalling because they have no proper answer for you. They haven't answered anything that I've stated whatsoever. You gotta love them even through prosecution, says Rami Salami. He's an idiot. I did not get your email. I got a lot of emails, so I probably missed it. Can you satisfy a fine with silver and the silver satisfy the debt? They can't take you to jail. I don't know if that was a question or a statement. If someone's claiming that you owe them something, then I'm pretty sure it's UCC 3-604 or something like that, and you make a counter offer in something of equal or more value and they reject it, it doesn't matter who it is, then it's considered discharged. So if that was a question, then yes, you're right. All right, if there's no questions, I'm gonna give you all a little bit more to type in your questions. Where should you adverse possession case be filed? It's not an adverse possession case, it's an adverse possession. And you can, but don't have to, file it in City Hall. They're never going to honor your documents. So the question is, why are you in their venue? Why am I in their venue? It's because they know where I live, number one. Number two, there's no one here to help protect me. That's number two. Number three, on all their paperwork, it says if you don't show up, we're gonna arrest you. That's why I show up, because I'm not a fucking idiot. I'm not a retard. That's why I show up. They threaten to arrest me. They threaten to fine me. So every time I go, it's under threat, duress, and coercion because they keep threatening me. If they didn't threaten me, I wouldn't fucking show up. But they keep threatening me. Every time they send me something in the mail, it says if you don't show up, you're going to jail. That's what it says. They don't say if you don't show up, then, oh well, then we're gonna drop the charges. Nah, it says if you don't show up, you're going to jail. That's what it says. So, if you're dealing with a gang of people who already sent a violent fugitive task force to your house for an alleged warrant that they never showed you, broke down your door, threw you in prison for $20,000 with surety, I'm dealing with people who ain't playing. So if on their paperwork says they're gonna send you to jail, especially after a magistrate said you're innocent until proven guilty and threw me in prison, then I'm probably gonna believe that paperwork that says if I don't show up, then they're gonna send me to jail. We have to stop being stupid. We have to stop being stupid. We have to stop thinking that just because we know law that they're not gonna violate it. What the fuck? How dumb are we? Look at what happened to Sharon. What happened when she didn't show up? What'd they do? Issued a motherfucking warrant and then arrested her anyway. Which made it worse. So that's why we're showing up. That's why we're showing up. On everything that we sign, it says what? Threat, duress, and coercion. Why? Because they're threatening to arrest us if we don't show up. Now, if y'all were here and we could protect each other, then I wouldn't fucking show up. It would just be, here's the affidavit. You never answered them. I'm not showing up. But since we refuse to live close to each other, since we refuse to help each other until it's too late, since we refuse to establish counter or preventative measures to prevent things like this from continuing to happen, since we refuse to do anything that requires any type of sacrifice, since we refuse to do all those things, this is what I have to do. Period. Rumor has it that you are going to attempt to get Sharon Tracy Gale Bay out. Is that true? Does it look like I'm going to do anything like that by myself like a retard? Y'all have to stop listening to these idiots. Y'all really do. What to do for an illegal carry? An illegal carry? I'm not sure what you're talking about. See, they think it's all paperwork and it's not. Yeah, it's not. They're actually warring against us. You're absolutely right. They put us through the ringer. Why are they putting us through the ringer? Because we refuse to unite. We refuse to organize. We refuse to make any type of sacrifices to instill preventative measures from them continuing to do what they do against our people. We refuse to do that. That's why they're doing whatever they want to us. It's pretty fucking simple. So is the plan to keep pushing it back? What can we do to get it dismissed? What can we do to get it dismissed? Shit, move out here and let's protect each other. That's what we can do to get it dismissed. Let's form a government. Because with a government, we can send officials to their government and say, hey, why are you violating our treaty? With the government, we can have our own buildings with our own armed guards like they have and say, you're not about to take any of our officials. We can do that. But Moors don't like that kind of talk because they get scared. So if you don't want to do that, then we can't do nothing. That's just the truth. You signed up for the study group but didn't get the information. I'm not sure what you're talking about, because if you're talking about the Rise and Moors application, you don't sign up. You purchase the information. So I'm not sure what you mean. illegal carry of arms is what they charged me with. There can be no such thing as an illegal carry of arms because if you read the Second Amendment, it says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. So there can't be an illegal carry of anything. Can you file in a federal courtroom after you had it in a district court? Yes. Bro, filing in federal court is less than $50. The other fee is for the de facto. I never paid anything to file anything in federal court, and we have a case open right now. Look up Leonidas Jabir Bay versus the Commonwealth of Massachusetts. All right, my wife's calling me because food's done, so peace. Stay active, not passive. Don't let bitch ass niggas put fear into your body. Don't let niggas whose hearts pump 10 pico tell you about what we should and should not be doing. Your prophet said these Europeans are not going to stop till they look death in the face. Us sending them paperwork is not them looking death in the face. Us showing up to court 50 Moors deep, that's them looking death in the face. All of a sudden, we show up to court with 50 Moors, and all of a sudden, I'm not on the docket. So all of a sudden, I'm not on the docket, but when did they send this? But June 15th, 2020, the Office of the Attorney General, Peter F. Norina, via his assistant, Megan E. McDonald, or McDonough, whatever, send me a document with regarding a case, but I'm not on the docket, though. Once there's 50 Moors around, I'm not on the docket. Y'all have to look at it for what it is. Stop dumbing down, stop dumbing yourself down to the point where you can't see that these people are playing games. But yeah, like I said, I gotta eat food. Peace. Because this is the physical plane. I'm a divine being on a physical plane, so I have to eat food. It's not just it's just a spiritual hunger. Nah, I have to physically eat to stay alive. Just like if I have to defend myself, I have to physically do it. So stop listening to these hoe-ass niggas.